set. Good morning, and I want to thank everyone for joining us today. It's an important announcement. Let me first thank the staff and the attorneys at the Consumer Protection Division of the Office of the Attorney General. Their work and working in coordination with or cooperation, partnership with the county has led us to today's announcement. I want to particularly thank Assistant Attorney General Dawn Singleton and Deputy Chief of our Consumer Protection Division, Karen Valentine. And I really do want to thank Prince George's County government. I want to thank you for your work, the work that you do every day to ensure the health and safety of our residents. And I want to thank the Chief Administrative Officer, Tara Jackson, her presence here today, and the work and the leadership that you demonstrate day in and day out. I know that we share the belief that all Marylanders deserve to not only feel, but to actually be safe and secure in their homes. Owners of multi-family housing units are required to hold a license in the state of Maryland. It's simple, it's straightforward, it's the law. But it took the Heather Hill Property Company 25 months after they purchased the property, which stands behind me, to even apply for a license. For more than 2 years, families at their property had to endure deplorable living conditions, including mushrooms growing out of the floors and cabinets, air conditioning and heating systems that don't work, and mice and roaches, rodents roaming throughout their homes. This landlord advertised renovated 1, 2, and 3 bedroom units. But what they didn't do is tell prospective tenants that the property was not licensed, or about the code violations, the infestations, the inoperable stoves, the roof leaks, the refrigerators in disrepair. Instead, when residents complained, Heather Hill Property failed to respond. They didn't fix the apartments. They didn't make the homes livable. Nothing, not even when the Prince George's County Department of Permitting, Inspection, and Enforcement continued to issue them notices of violations. Nothing. After more than 2 years, they finally applied for and received a temporary license. And what did they do? The very next month, they ran to court. The property company ran to court and filed more than 100 failure to pay rent claims against their tenants. And the code violations continued. Prince George's County suspended the temporary license after finding that every single building in the complex had housing and fire code violations. And Heather Hill failed a fire safety inspection. And yet, Heather Hill Property Company continued to charge their residents rent and threatened to assess late fees. The Office of the Attorney General is filing this action because the owners and operators of these apartments violated the Consumer Protection Act and the Consumer Debt Collection Act, laws that are designed to protect Marylanders from harmful business practices. In our action, we are seeking to recover the money the owners and operators took from their tenants through their unfair, abusive, and deceptive practices, and to force the company to stop charging tenants rent and to stop renting any vacant units so long as Heather Hill Property is not licensed. It doesn't matter whether you live in an apartment that you rent or a house that you own. Your home should be a place of safety and comfort. Home is a place for children to rest in, for parents to recharge, a space to share a meal with your family and talk about your day, and a place to make happy memories for children. But that's not what the residents of Heather Hill Apartments have experienced. Heather Hill Property Company, to them, a home is simply an opportunity for them to make money. So let me be clear, landlords. If you don't protect your tenants, the Office of the Attorney General will. Housing is a critical issue in the Office of the Attorney General. Earlier this year, our Civil Rights Division filed its first lawsuit, a housing discrimination case against a landlord on the Eastern Shore. Our complaint alleges that the landlord preyed on vulnerable women. Women experience homelessness, single mothers, women who don't have much money, and offered them benefits like reduced rent in exchange for sexual favors. That lawsuit sent another message to landlords. If you sexually harass your tenants, the Office of the Attorney General will hold you accountable. The Office of the Attorney General will not allow landlords to jeopardize the health and safety of Maryland families just so that they can turn a profit. And with that, I'd like to turn it over to Karen Valentine, Deputy Chief of our Consumer Protection Division.
Thank you, Attorney General Brown. As Deputy Counsel to the Consumer Protection Division, I oversee enforcement of our housing matters. I'm going to talk a little bit about what the Consumer Protection Division does specifically for tenants and provide a few tips that tenants can consider when applying for a rental property. The Consumer Protection Division assists consumers with consumer complaints, educates consumers, and enforces the Consumer Protection Act and other consumer protection laws, including laws that are in place to protect consumers. Our housing attorneys initiate enforcement actions if we identify particularly egregious or harmful practices not only by landlords, but by new home builders, home improvement contractors, project managers and developers of homeowners associations and condo associations and others that might provide goods and services in the housing space. If a consumer is having a dispute with a landlord or another merchant, the consumer can contact our mediation unit. In fiscal year 2023, the mediation unit received over 10,000 consumer complaints and over 17,000 calls, and received over 2.6 million back for consumers. Disputes between residential landlords and tenants is one of the mediation unit's highest volume subject. So it's the biggest subject that the mediation unit gets complaints about, landlord-tenant issues. There are actions that consumers can take during the application process to help reduce potential problems that might arise during the application process. For example, before agreeing to rent a property, a landlord generally will ask a person to complete an application and to pay an application fee. The applicant should make sure that the document that they are signing is actually an application and not the actual lease. And the applicant should not sign a lease until they are very comfortable with the terms of the lease agreement. If a landlord asks for the prospective tenant to pay an reservation deposit or a security deposit before they sign the application, the consumer should make sure that they ask the landlord to write on the receipt for the monies what the refund policy is, that they will be getting the money back if either they decide not to go through with the rental or the landlord decides not to go through with the rental. When a tenant experiences serious or dangerous defects in a rental unit, the tenant has the right to go to the district court and seek to put their money in an escrow account instead of giving the money to the landlord. The tenant, however, needs to be sure that that's the process they take. If they just stopped paying the rent, the landlord could come after the tenant. for failure to pay rent, and the landlord could bring an action against the tenant. So the tenant, while they do have the right to file an escrow claim, they need to follow that process. Besides filing a rent escrow claim, they can complain to their local jurisdiction authorities, or they can complain to the Consumer Protection Division, to our mediation unit. Tenants can report actually any kind of dispute they're having with the landlord to our mediation unit. Our consumer hotline, our mediation unit hotline, is 410-528-8662. And we also have a toll-free number, 880-743-0023. For Spanish speakers, the number is 410-230-1712. Consumers can also go online to our website and download and print a complaint form, or they can file a complaint online. We also have available on our website frequently asked questions that tenants might have, and also we have a pamphlet that provides tips, additional tips than the ones I gave, that can help them to avoid disputes. Next up is Tara Jackson, the Chief Administrative Officer for Prince George's County.
Thank you, Karen. Good morning, everyone. On behalf of County Executive Alsobrooks, I first want to thank Attorney General Anthony Brown and his office for taking this necessary action, and we appreciate their ongoing cooperation with the county on this matter. It's imperative that we partner on this because our joint message is crystal clear. There is no excuse for the actions of Heather Hill Property Company. Its conduct demonstrates disregard for the health and safety of our residents, and they should be held accountable. Since April of 2022, Heather Hill has been cited by our Department of Permits, Inspections, and Enforcement for numerous violations. You've already heard infestation of bats, rodents, and roaches, roof leaks and rodent entry holes, leak stains and peeling paint on the walls, fire code violations, and mold in the floor and walls. Residents, again, as you've already heard, have reported instances of mushrooms growing through the floors. And we understand from the AG's office that they believe that there may be a correlation between these unclean living conditions and the health issues being experienced by some of the students that attend nearby Dent Elementary School. In addition to these unacceptable quality of life conditions, this past summer, the entire county witnessed the danger that Heather Hill's conduct put our residents in when extreme heat waves hit our region. Heather Hill property managers failed to maintain the building's HVAC systems, leading to dangerous heat conditions for residents in their apartments. To put it bluntly, Heather Hill's Apartments has been a repeated bad actor, and that is why we've taken measures against them. That's why DPI suspended Heather Hill's temporary rental license, and that's why DPI denied their rental license application last summer. And that's why we are pleased to partner with the Attorney General's office in taking additional steps today to ensure Heather Hills faces appropriate consequences. The health and safety of Prince Georgians will always come first. And the county is committed to making sure that those who subject our residents to unsafe conditions, no matter what those conditions, will answer for their actions. In addition, we know that extreme heat can be dangerous, especially to those of our most vulnerable residents. And the truth is that because of climate change, we expect to continue and experience more extreme heat during the summer months. That's why our actions on the front end are so imperative. The county has made significant strides towards becoming more climate sustainable and resilient. We've also made every effort to talk to our residents about taking precautions to protect themselves and those that they know may be more vulnerable. But today, we are imploring all apartment complexes to be more proactive because adverse situations may arise even when property managers are trying to do the right thing. We saw last summer that in some complexes that experienced HVAC outages, property managers attempted to address the situation, but a lack of access to necessary parts prevented them from expeditiously making the necessary fixes. So today, we are asking property managers to use this fall and winter to make sure that all of your systems are up to date, to be proactive so you don't have to be reactive. Please take this time to handle simple weatherization, maintenance, and energy efficiency updates. Make sure that your systems are prepared for the coming summer months. Our summer weather will grow more intense, and we need to be prepared on the front end. We want Prince Georgians to know that your well-being is and will always be our first priority. Protecting the trust that you have in us is a duty that we take very seriously. We hope it's clear that those who disregard the duty they have to our residents will face consequences. We will not take lightly any conduct or lack thereof that puts the health of our children our residents, and most especially our children, at risk. Thank you again to the Attorney General's office for being our partners in this important effort.
So we'll now take any questions that you have.
As we know, this isn't the first complex that's had issues, but how do the violations at this one compare to some of the others that you have seen around Prince George's County?
Well, let me just say generally that it's not a Prince George's County issue. You may remember my predecessor, Brian Frost, brought a fairly large action against Westminster Management. They had about 5,000 units under management in a variety of counties. So this isn't Prince George's specific. And as Karen Valentine mentioned, this is the single largest component of the complaints that we get. So what we see here at Heather Hill, we have seen elsewhere around the state. But just think about it for a minute. Think about it for a minute. Just take a second and think about what you're going home to this afternoon or this evening. That warm, comfortable, welcoming environment. That is not what the residents here at Heather Hill come home to. They come home to mold. They come home to rats. They come home to refrigerators that don't work. They come home to roofs that are leaking. So whether it's here in Prince George's County, Baltimore County, or anywhere else, the Office of the Attorney General, we are on the case to address this. And it is our intent not only to take action against Heather Hill, to disgorge them of profits, to make restitution to the tenants here, but to send a strong signal that throughout Maryland, this conduct is unacceptable. And we're going to use our resources to focus on the most egregious violators so that the residents are safe and held harmless.
I may have a follow-up on that, sir. I've attended some of your previous news conferences, yet there's something in this, in your tone, I'm not hearing. It sounds like you're angrier, if you will, or more angrier than I've heard you in the past.
Well, I don't actually welcome the characterization of angry. I am certainly committed and impassioned about this issue. You know, when we hold these press conferences, it's designed to inform the public, to put those who engage in these unfair and deceptive practices on notice, to educate the public on what they can do, because preventative medicine is often the best, but that doesn't mean the responsibility lies with the renters alone. So, you know, when we see this time and time again, you can't help when you're doing the kind of work that I'm doing, that Tara's doing, that Karen's doing, that Dawn's doing, that the folks at DPI are doing. You know, sometimes, quite frankly, I wouldn't say angry. If anything else, I'm probably sometimes get more frustrated, right? Frustrated. How are residents having to live in conditions like this?
I just want to double check. Where do they stand sort of in their licensing at this moment? Is all of that in order yet, or are they still sort of operating?
You want to speak to that?
Currently, they do not have a license, but DPI is working with them, the Department of permits, inspections, and enforcement are working with them, trying to get them properly licensed.
If they can't get licensed, or what's sort of the impediment to that, and what happens if that just doesn't work?
Well, let me get there. First of all, it does work and it will work. But in order to be licensed, you have to meet code, right? Fire code, health and safety codes, and the county will continue to work with this property owner to come up to code. The goal isn't to shut down apartment complexes. We need affordable, quality housing throughout the state of Maryland. So the goal is to work with property owners. Okay, sometimes you have to get their attention, like a statement of charges filed by the Office of Attorney General. This will be costly for them. Okay, they can avoid these costs by making the investments in the property. So I'm confident that they will, but we'll work with them. The county will work with them, bring them up to code, make sure that the homes are habitable, reissue licenses, so that this way the residents of Prince George County have affordable, quality places to live.
And in the meantime, the goal is to reimburse the residents for what they have to deal with. Do you have an idea as to how much that could be for them?
Well, let me just say that the hearing on the case that we filed is in February. And during the course of that adjudication, liability will be determined, the amount of damages will be determined, the penalties will be determined, fines. Part of that determination is what will be restitution or what goes back to residents. So all of that will happen in the course of the adjudication that is scheduled for, I think, mid-February of next year.
Your advice, perhaps I missed it clearly, but the advice to the tenants who feel they have a problem now, I just walked down there, everyone has issues. Should they be paying their rent? Should they be opening an escrow? What is the specific advice to the tenants who have issues with the property today, right now?
Right. So if you have an issue with the property, as Karen Valentine mentioned, go to the court. There's a process, opens up escrow. You pay your rent into that escrow. So when the issues are addressed, a determination is made about where that money goes. In the case of an unlicensed property owner, which is what you have here, an unlicensed property owner is prohibited from collecting rent in the state of Maryland, nor can they retaliate against renters who are pursuing their rights. We have heard of renters who are being threatened with eviction, and that's unlawful. It's unlawful in Prince George's County, and it's unlawful throughout many of the counties in the state of Maryland. So if you have a complaint, certainly call, and Karen provide the information. We can give it to you after. Call the Office of the Attorney General if you have further complaints about this property or any other property.
So people down there told me that, that the company says, oh, you owe us 20 grand. Is it possible that if you prevail in court, that these folks will not have had to pay the rent for the period of time that they were living here, but the place was unlicensed?
I'm not going to answer that question because that's going to be resolved, decided throughout the course of this adjudication. No, there are residents still here. Yeah. Yeah, you want to? Yeah, the answer is yes, there's still residents here. And as I mentioned, what we're seeking is that Heather Hill not rent out in the vacant units that they currently have. Because if they're not habitable, don't fill them. But we're also not trying to displace people, right? These are tough choices. This is the rock and the hard spot that no one should have to face, right? Deplorable living conditions versus homelessness, and that's the position that Heather Hill is putting these tenants. Well, I know they own multiple properties throughout the state of Maryland. This is the one that is the subject of our statement of charges.
Two more questions, please.
So you said they're not licensed right now, but it's also illegal for an unlicensed company to secure rent. Does that mean the residents don't have to pay their rent?
I just gave you statements of fact and law, right? In Maryland, right? An unlicensed property owner cannot collect rent.
So they don't have to pay if they don't want to.
In Maryland, an unlicensed property owner cannot collect rent.
One more question. All right.
Thank you, everybody.